Okay. Good morning. Thanks for joining us today for our webinar entitled, Why Do I Have to Hire That Felon? Understanding California's Background Check Laws. My name is Denise Keddy, and I am your moderator for this session today. I want to go over a couple of quick housekeeping notes before I introduce today's expert panel. Our webinar will run about 55 to 60 minutes. We'll save some time at the end for some Q&A. Don't worry if you have to leave the webinar a little early, or if your question doesn't get answered, or if you want to share this webinar, it will be posted in the next day or two on the Ethos YouTube channel and the Merhab, Robinson, and Clarkson YouTube channel. Please take a moment now to download the handout. I listed it in the chat. If you have any questions or problems, you can chat me, Denise Keddy, during the session. If you have questions during the presentation, please post them on the Q&A area of the dashboard. If you like your question directed to a specific panelist, please note that when you are sending it in. Just a reminder, today's webinar is being recorded and all accompanying materials are protected by copyright. Our presentation today is for information only purposes and should not be relied on in reaching a conclusion in any area of law. The information offered during the webinar is as of today, March 16th, 2023. As always, we recommend that you consult with your own legal counsel to address your specific situation to ensure you have the most current information on legal matters. Today's webinar has been approved for 1 HRCI credit. If you are certified through HRCI and want a credit for today's attendance, please type HRCI into the questions section on your dashboard, and we'll send you a certificate of attendance once you have completed the follow-up evaluation. Let me introduce you to our panel today. Our legal expert is Curtis Urian. He's an associate at the law firm of Merhab, Robinson, and Clarkson in the firm's transactional department, where he advises clients in real estate, finance, and unemployment law. In addition to all his work at the firm, Curtis has contributed articles to law journals and lectures at the business and political science departments of the American Jewish University, Los Angeles. Curtis has been recognized as a rising star by superlawyers.com for the last 7 years, from 2017 to 2023. Our human capital expert is Linda Duffy, founder and president of Ethos Human Capital Solutions. Linda is known as the people problem solver, and Linda and her team are known for building the magic of the human connection with their consulting, recruiting, training, and organizational development programs. Linda and the Ethos teams work with your company by developing strategies for business leaders to get the right systems, people, and culture in place within your organization so that you, as a business owner, can focus on running your business and achieving your goals. Linda, can you introduce our special guest presenter today?
I would love to. I'm very happy that Tim Santoni, who is president of and CEO of Santoni Backgrounds and Investigations, and actually Santoni Worldwide, has agreed to join us today. I've known Tim for a number of years now, probably more than, I don't know, probably like 12 years or something like that. We know each other through a business networking group. And Tim's dad started this company. Tim sort of grew up in this company. He's running it now. And it's a great team to work with for any background check needs. And he also does a lot of investigations worldwide. So Tim, as you talk today, feel free to work in a little bit more about your background. Tim's married with how many kids? 4, 5, 4? 4 kids. So he's got his hands full when he's not helping his clients out. So Tim, thank you so much for joining us today. Very happy to have you here. I love being able to work with Tim because it's nice to be able to pick up the phone when you have a question about a background check and actually talk to a person, that knows what they're doing. So thank you so much for that, Tim. So let's just take a quick look at our agenda that we're going to be working through today. So these were the learning points that we added in the webinar registration. So we're going to take a look at the background laws that come into play, talk about at what points in time you may not be able to conduct background checks. what you can include, what you can't include. Tim's going to do a great job explaining the difference between the National Criminal Database search and different county searches. He's actually going to walk us through a couple of background check reports, which is going to be really good. We'll talk about the adverse action process and how you need to approach it if something does show up on your background check. And then Curtis is definitely going to be talking about some of the penalties if you don't do this correctly. So for those of you that have been with us before, you know, we have a pretty casual style. As Denise said, just drop into the chat or Q&A area any questions that you may have, and we'll get to those toward the end. So Curtis, can you kick us off by sort of telling us what laws apply when we're talking about background checks?
Absolutely. Thank you, Linda, and thank you, Denise, for the introduction. This is an interesting topic that I'm glad we're having this webinar on. It's not received the type of attention that I had hoped for. I still see a lot of clients that are either don't know about this law or not, or about the laws that we have listed here, or are not complying with them properly. But we've listed out a handful of laws that apply when when a company goes to hire an employee. First one we've listed, and is the one that we're going to talk about the most here today, is California's Ban the Box law. Or otherwise known as the Fair Chance Act. So this is a law that went into effect a couple of years ago that prohibits an employer from performing or obtaining a background check until certain actions have been taken. And we're going to be going through those actions and what to do here. The Fair Chance Act was modeled off of the San Francisco Fair Chance Ordinance, and Los Angeles had modeled their own law after the San Francisco Fair Chance Ordinance. So if you're in Los Angeles or if you're in San Francisco, there may be some minor differences between your local city ordinance and the statewide Ban the Box Fair Chance Act. But for the most part, the California law was modeled after and follows the San Francisco Fair Chance Ordinance. So there are a lot of similarities between the various laws. We're also going to touch on the Fair Credit Reporting Act, meaning if you want to obtain a credit check or a credit report on an applicant before you hire that person, there's some rules you have to follow in circumstances where you can and cannot obtain that credit report. We're going to talk briefly about the California Privacy Rights Act. This is not a new law, but it's been an interesting law, but it has gone into effect for employers this year, and has to do with covered employers providing certain notices and establishing certain policies with regard to employee and applicant privacy. We also have the California Information Privacy Act, which entitles employees and applicants to certain types of information. And we also have to discuss and cover the anti-discrimination laws.
Great. So in terms of timing of background checks, you know, I think the first thing that's important for everyone to understand, there's no legal requirement to do background checks for most industries, right?
Right.
So if you're regulated by, you know, FINRA, for example, you know, in the financial industry or other places, they might have requirements, or some healthcare might have requirements. But generally speaking, Tim, you know, what are sort of the rules on this? Is there, you know, any industry that absolutely has to do background checks that you know of?
Yeah, I mean, again, there's compliance for different industries where there's requirements and the suggested guidance, like if you're running a daycare or a nonprofit and different things, and those could involve live scan fingerprinting and different things like that. As it relates to specifically doing, you know, required to do background checks, we're finding it's mostly requirement in master service agreements and contracts a lot of our clients have with their clients in order to do business with them. And again, in regulated industries like, you know, SEC, FINRA, and different folks where their license is contingent on that, the agency that does that licensing will have to do that. So it's usually, there's a lot of different scenarios where background checks are a recommended practice or required for compliance. It doesn't necessarily mean that all businesses are compliant or are following those things or managing them properly. And that's, you know, where, you know, having some HR guidance and a team in place, and obviously consulting a legal counsel on how to do that and be compliant is super, super important. So you're taking the laws and rules and then adapting them to the business practice.
Yeah, absolutely. And generally speaking, background checks should be done after the offer, right? You can make it contingent upon passing it, but we're going to talk about some of the rules around what happens if something shows up on a background check. Now, Curtis, there's exceptions though, right? In terms of both timing and also when you can do background checks for certain people.
Right. So the predominant requirement of the Fair Chance Act is that an employer not perform a background check until after presenting the applicant with a written conditional offer. There are some exceptions to that. Some exceptions would be where, like Tim was talking about, where if there's a legal requirement, perhaps if a company is a government contractor and there are government regulations that require a background check before hiring an employee. And another exception would be for obtaining DMV records, because there's an exception where, again, this is going back to the same exception where if the law requires a background check, you can do the background check and obtain those records without going through the fair chance process. And included in that for drivers would be DMV records, since a driver must be licensed to drive. And there are also some other exceptions that we'll talk about for current employees, when it's permissible and when it's not permissible to do background checks for current employees who have already been hired and have already started working.
Let's talk about that now, Curtis. So for current employees, what are some of the exceptions for when you'd be able to do a background check after they've started?
If you are the employer, you can at any time obtain publicly available information yourself from any publicly available repository of that information after employment has started. But after employment has started, if you are the employer and you're going to hire a service such as a background service like Santoni, then there are only a limited number of circumstances when you can obtain a background check. One of those circumstances would be if there's been employee misconduct, such as employee violence or employee theft or allegations of harassment or discrimination. So the first circumstance is if there's been employee misconduct, you can do a background check. And then another important circumstance, again, is relating back to what we've talked about, this exception for when a law requires you to do a background check. So you can do background checks of employees. You can search their DMV records if they're required to drive for work, such as if they're drivers, or if your business is taking on a new contract with the government and you've already hired everyone, but the government contract requires that everyone be background checked. You can then go ahead and do background checks because there are laws and regulations that require it. But generally speaking, after employment has started, it's only in those limited circumstances, if there's been misconduct, if there's a law that requires it, or if you're doing some kind of compliance work or where it's regulatory required.
Yeah, we see this a lot, and I'm sure, Tim, you see this too, where, maybe an existing company gets a contract like with the ports of LA, right? All of a sudden, everybody has to be drug tested, which typically you wouldn't do unless for cause, right? Or pre-placement. And the same thing, they may require a background check. So if that's the case, Curtis, Tim's working for us, right? And I come to you and I say, hey, we want to background check Tim because we want to assign him to the port. What if he fails the background check? Do I fire him?
If that employee fires the background check and you have other work available, then you would need to reassign and have that employee work on other work that's available.
Got it. Okay, cool.
And one other thing just to point out there, just where employers come to us a lot of time and want to do it after the fact and discreetly, remember, that's great. But if something comes up that is adverse or you don't have authorization, you put yourself in a really bad position. So yes, it is possible. It's not a recommended practice because you really need to have authorization. And most employers are not going to ask for authorization after the fact. And that means that they're entitled to a copy of the report. So if something adverse comes up and you want to discontinue your relationship with that employee, you're really in a doubly bad situation from a exposure perspective.
Great point. Let's talk about things that you can and cannot include in background checks, Tim. I know, like when I log into the platform, there's a whole bunch of different options for me. So you want to just talk about this for a second?
Sure. Yeah, I mean, there's a variety of different searches that you can run, and as an employer, I think it really makes sense to consult with an expert who understands the business, the positions you hire for, the risk tolerances, and kind of the insurance and compliance requirements. At a basic level, I think that the first kind of bullet here really talks about the basics of a background check. The SSN trace is really a tool used to develop identity and address history. Your national criminal database and sex offender registry is kind of a base level database search that's, I'll talk about a little bit later, in California is a first step, but there's a lot of holes with that. Your county level records for criminal, federal criminal for white collar, crimes involving, I shouldn't say white collar, but criminal offenses for, things that cross state lines: embezzlement, fraud, theft, wire schemes, IP theft, other kind of trade secret things where there's federal things. And we talked about driving records as a core piece. I think that the two really important things to look at are employment verification and education. Those are two areas we find the most amount of falsification or exaggeration of information.
Yeah.
Again, they have a professional license that's necessary for the job, verifying that it's accurate and current, especially in the healthcare space. And if there's any credentials or any other references that are required in there. We'll talk a little bit about, I think that under the Fair Credit Reporting Act, we talk about credit reports especially for California employers. We'll talk about a little bit why those should be used and not used, or not used. One thing I want to point out on credit reports, that in California and across the country anyway, for employment purposes, a credit report cannot contain a score, a FICO score, or a score that most people use to assess creditworthiness. And also the government has removed public records. So bankruptcies, judgments, and liens have been removed from credit reports. So if you do have a probable reason or a criteria with the position to run a credit report, you better be prepared to analyze it and review it. It creates a lot of questions. And if you're not, then run a bankruptcy, judgment, lien search outside of the scope of the credit report. And it'll probably give you more actionable information unless the credit report is required, like you're working for a credit union or a bank or financial institution that's required.
Great. Let me ask both of you about workers' comp records, because I think we get this request a lot, right? Where people call up and go, I don't want to hire this guy, unless I can take a look at workers' comp history, or I know this person filed some sort of claim at against their last employer, right? And so they want to do a workers' comp record background check. So what do you guys think about doing that type of check before somebody starts work?
So I'll let Curtis handle the legal part of it. I'll talk about the practical part of it. So we're talking about California specifically. So in California, the only methodology of searching for workers' comp claims is through the EDEX system, which is a system indexed by a social security number for litigated claims only. So this means if you're hiring people without a valid social or using someone else's social, you could find records that don't pertain to them, number one. And number two, you're only filing litigated claims. So that means if the claim's accepted because they got run over at work and it was not litigated, that will not show up. Also, there's nothing in that system that puts up a red flag or says, oh, this is fraud, or dig deeper. It's just an indication that they were potentially injured, or there was a claim that was litigated. And for the most part, in the pre-hire process, unless Curtis can weigh in otherwise, it's highly illegal, unlawful to do that as a pre-screening aspect for the condition, the employment and the offer.
Well, it is possible, but it's highly risky. And the reason why it's highly risky is because if I'm a potential employer, I see that somebody litigated over a back injury, and I've decided not to hire that person because I found out about their back injury. I'm now discriminating against that person because of a medical condition. So it's possible you can do it, but it's very risky, and we don't recommend doing it. Sometimes we have employers who will do workers' comp searches and then ask their employees to list on their employment application any potential disabilities. And of course, the employee wants the job, so the employee doesn't do it. The employer later finds out about the injury. Sometimes the employer will want to try and say that the employee was dishonest on the application and use that as grounds to dismiss the employee. But it's possible, but still it's extremely risky. I generally recommend not doing it.
Yeah,
And Linda, alternative to that too, just because I think a lot of employers are worried about hiring people with pre-existing conditions that are physically limiting them to do the job.
Right.
That's the main issue, right?
Usually, yeah.
So
I know where you're going with this, so go ahead.
yeah, so the recommendation there is that if you establish the profile, the job description of what's physically required for that position through your, your onboarding and your handbook and your documentation as far as that position, it makes sense to do a pre-placement physical to establish their physical condition. And if it's a lift test added onto there that say, 20 pounds, they need to be able to lift. So at the time of hire, did they pass the physical and did they pass that lift test that met those requirements? You establish a baseline for their physical abilities before they move into that position of employment, which gives you a little bit more leverage going forward and gives you more relevant data to actually make that decision with.
Exactly. We recommend the same thing, Tim, and we just tell people, make sure that whatever whatever the job requirements are, make sure those are essential functions, right? Not a one-off, oh, every once in a while the person has to lift 50 pounds, right? But they have to lift 30 pounds every single day. Then send them to the doctor, but make sure the doctor knows what she or he is, evaluating the employee or the candidate, on, and then make sure that they're fit for duty. But again, if for some reason they fail that, don't just automatically fire them. You need to get us involved or Curtis involved or somebody that can advise you on how to handle that. Social media is always a big one, right? Because one of the things I think we need to talk about, Curtis, is, just because you see something or, somebody volunteers something doesn't mean you can just automatically use it in your decision-making, right? So talk about that a little bit.
So my personal recommendation is to just not look. Because social media, Twitter, Instagram, Facebook, it's not real, and people embellish and people make stuff up, and there's a lot of complaining and a lot of disparaging language. So I tell I don't think, this is just my personal opinion, it's not a legal opinion, I don't think you're going to get a good assessment of an individual based on their social media presence. But it's possible you can do it. I just don't think it's helpful.
What are your thoughts, Tim?
Yeah, so it's a good point. I think that in today's world, when we have a lot of different information out there and the culture of companies and what people are saying on social media is irrelevant, and it can cause issues with the brand and the company and whatever else. Let's be honest, a lot of people are doing it, whether managers are looking and not saying, they're just doing it. So there is a compliant methodology of looking for social media, and it follows the FCRA guidelines. And I think that using a provider that does it well, and really what you're focused on is making sure that the profiles are public facing. You're limited to your top 5, your Facebook, Instagram, LinkedIn, TikTok, Twitter, and then kind of web news. And then there's really great AI tools that then analyze the information as it's, violent behavior. Is it, what are they saying? Pictures, images, and analyzing those things for a risk. And as long as you're confirmed that the profiles that we're asking for, we ask for the profiles of the applicants up front. They're providing them to us, so then we know that that's a pretty accurate way of determining they belong to them, and then analyzing the information to determine, is that information disturbing, violent, or it cause other problems is there. To Curtis's point, it's very difficult to make a subjective decision based on that. I think what it says about a lot of employers are moving toward it because they're concerned. And by doing it, you're sending the message to the applicant that we are concerned about this, we are aware of it, and we do take it seriously. So whether you find something or you don't that's disparaging or adverse, I think it definitely sends a message, and it explains to the culture of the company.
Yeah, really good point. The last bullet point here, one of my personal favorites, is the vexatious litigant list. This is just a list that's maintained in the state of California through the court system about who has been filing like way too many lawsuits. And so if a judge, feels like this is just somebody that's going to keep doing this, they actually add them to this list, and it changes all the time. So if you just Google that, you'll be able to find it. So again, you want to be careful when you get the information, what you do with it, and how you proceed, but it's out there because we get that question a lot too. Credit reports, if I can summarize all of this on one page, let me see if you guys agree with me. What I'm going to say is, they're really trying to prevent identity theft at a highest level. That's what they're trying to prevent, number one, I think. And number two, certainly like embezzlement, things like that, right? But what the question that comes up to us a lot is, let's say we've got some restaurant clients and they say, oh, well, we want to, we want to run a credit report on all of our wait staff because they're going to be able to take people's credit cards, right? And the law specifically says, no, that's not what we're trying to do, right? Just because you're running somebody's credit card, you would not be able to, you might be able to steal the number, and use that, but you're not going to be able to go buy a car or, do something like that, because you don't have their social, you don't have a lot of other information. You guys agree with that assessment, or is there other stuff that they need to be aware of?
Yeah, I agree with that assessment. So the law specifically carves out these 8 or 9 exceptions for when a credit report can be obtained on an applicant. And when somebody's applying for a job, it's usually because they're broke. And if they're broke, they usually have bad credit. So the law also wants to protect people with bad credit and give them opportunities to get jobs to clean up their credit. So that's why there's a prohibition on obtaining credit reports subject to these 8 or 9 exceptions. So if like Linda said, just because somebody is running a credit card doesn't mean you can do a credit check on them. But there are certain positions where if somebody is accessing or is handling at least $10,000 worth of cash or more on the regular, then that person can be credit checked.
Okay, awesome. Anything you want to add, Tim?
Yeah, I would just add that I think that like I mentioned before, the lack of information available that used to be available through a credit report that's not there is a limiting factor, in my opinion. And the other part of that is that I think that because we talk about Fair Credit Reporting Act and credit reporting agencies, that there's just this idea that we have a lot of clients that come to us and just say, we want to run a credit report, because that's just been a historical trend as what was always included. And I think that trend has now moved on.
All right, awesome. Okay, Tim, share your expertise with us.
Yeah, so in this section, I just want to kind of clear up a myth that we get a lot, and that is the difference between a national criminal search and a county criminal search. So if you're running a national criminal search, a typical point and click, go online, click a button, pay your $5, $9, $10, $15, and you're getting back records instantly. Just want to make sure you understand what that is. That is a data-driven search that comes from a variety of different court, government databases, arrest records, and it pulls them back through and it tries to assemble them together. And it's a variety of different things. The data there is typically outdated, usually doesn't have enough identifiers to actually report. I mean, there's not a disposition, a full date of birth, a full name, and all the different charges with the corresponding dispositions in order to report that. So if you're running that, it's quick, it's fast, it's easy. If you're in California, and this webinar is specifically for California, you have to keep in mind the limitations of the court system within the several counties within the state of California. Majority of those counties do not report to the National Criminal Database search. So if you're in California and you run this search, we get clients all the time like, this search is so easy, it always comes back fast, it's inexpensive, and there's no hits.
Right.
Well, the reason that there's no hits is because the fact that those courts within California are not reporting to the National Criminal Database. Additionally, within California, there's not a statewide database like there are in other states like Colorado and Utah and other states like New York. So there isn't a statewide available search. So the National Criminal is the only thing available. So you're going to get those things back. And again, the National Criminal is a starting point. It usually includes watch lists and high-level things that are available, as well as sex offender registry. So it's not necessarily a bad thing. It's a very inexpensive, basic way to start. So
Tim,
you can see here,
I'll just say that comes up for us a lot when we're talking about to a client and they say they're doing background checks. I'm like, great, what do you check? Right. And they go, oh yeah, we got this great deal. It's like, like $9 or something. We're going to, check the national, criminal database. And they make it sound like, oh, that's like one-stop shopping. Like everything ever has been reported there. And I said, it's not worth anything. Right. So people need to understand like what you're actually getting. And I think this right here is one of the biggest misunderstandings.
Sure. Yeah. And I think another misnomer is that, so in the National Criminal Search, it's looking for criminal records throughout in the available databases. This does not include federal. It doesn't include a lot of other things. Arrest records in California are not there. It's missing a lot of things that people assume that a national search would include. So it's very, very, very common. So there are this many counties, and remember, every single county throughout the United States has different protocols on how those records are accessible electronically, scraping, in person, mail requests, requiring additional authorizations. So remember that you may be in California, but you're hiring someone, especially we see clients now hiring people throughout the US that have relocated, or maybe you have remote workers and you're based in California, but now they live in Florida. So you need to be aware of those things and be working with someone that actually can pull records there, and beyond that, internationally, right, in this kind of environment that we live in. One other thing to point out, the national criminal search, that's $9, $10, $15 search, the records that come back on that, if there are hits, so let's just say there's a hit in Texas for burglary, it's incumbent on the background screening provider and the employer to verify the record pertains to the applicant, their full name and date of birth, and that the charges and dispositions are reportable based on adjudication rules where you're working. So if they're a California employer, be California. If it's Texas, it'll be Texas. But so the standalone search of a national crim gets you partway there, but still a county level search is required to do that. And again, when I talk to clients a lot, this is the biggest point of misinformation that comes up, is that, we did the national criminal, why didn't you do the county criminal? And there's a few reasons why. So let's move on to the next slide and talk a little bit specifically about California. So in California, like I mentioned, there's not a statewide available search. And in fact, the reason that if you look at it this way, there's 14 counties that actually require an access fee. So we actually pay a pass-through fee just to access records. For instance, in Los Angeles County, it's around $5 just to conduct that search and pull back those records. So if you're doing that $9.99 search, that they're not adding on $5. So there's no way they could get that record from LA County or other counties that require a fee. And even in this day and age, I think it's important to point out there are even some counties like Sacramento and Ventura that are now requiring in-person searches, either through their point of service system, their computers, or through the clerks, because of a lot of the limitations and issues that have come up as it relates to privatization of information and kind of their limited capacity to provide online resources and data available to the masses. So you can believe that there's still a requirement. So if you're doing Sacramento, you got to walk into the courthouse and make the request.
Wow.
That's not going to be available through a national criminal search with one click, in that regard. So
For
a little
sure.
bit about that.
We always recommend that they go back 7 years and do counties that they lived and worked in. Is that sort of what you think is the right standard?
Yeah. So the best standard to go by is the in California, especially, we run that SSN trace. We gather information on the onset as to where they lived. Generally speaking, I like to point out to clients that people have generally lived in 2.2 counties over the prior 7 years. So based on the applicant provided information in the social trace, we pull that information back, you run the national criminal, and then you're searching counties of residence going back to those 7 years. So people are like, well, how much is that going to cost? Well, if you can do the math, you can see, okay, it's approximately 2 counties in general that people would have lived in, and that's what you're searching. So you're creating this kind of web to blanket where people lived, where you would pick up records. And you're doing that to make sure that you create the best possible background profile you can with the resources and time you have to pull back most possible relevant, hits that would be out there.
Awesome. Okay. So let's take a look. Let's see if I can do this. All right. So we're going to start. Can you see that one, Tim? I
Yeah,
can't see what you guys are seeing, so I just want to make sure it's pulled up. Okay.
Yep. No, this is perfect. So we're going to look at 2 different kind of reports. One's a very clean profile and the other one's a very messy profile. But it's important that the background report, that you don't need to know all the ins and outs of it, but the language on here, as far as the civil codes and the languages and the fonts even, all those things are important because as Curtis can attest, all those things bring cause for plaintiff attorneys to come after folks, employers and background screening providers for not following these rules. And there's very specific rules under the FCRA and the California rules specifically as to what must be there. You can say following statements in 12-point bold font. Scroll down a little bit there, Linda. So you can see at the identity development section, we're obtaining information on the applicant. We're trying to figure out where they've been so we can profile them and understand where their records might have appeared. So you can see in this situation, there's 2 different locations and addresses that's come from the SSN trace. And then you're running the national criminal database plus sex offender, showing you and documenting what's been done. And then from there, if you scroll down a little bit further, you can see that there's, in this situation, there was also verifications of employment and education. So you're asking the applicant wherever you worked, and you can limit that to the last employer, the last two, or the last three, as well as with education, and verifying that what they represent is true and accurate and correct. I want to point out on the employment verification side, a lot of employers are leery about verification of employment for the prior employer because maybe they're in transition. There is the ability to eliminate the prior employer to avoid contact with them, so they don't get tipped off the fact that the employee is leaving. And I would say that the biggest issue around employment verifications at this juncture is the extreme cost associated with the work number. You guys may be familiar with the work number. It's a necessary evil. They bought up a lot of records. There is a solution to get around the $80 to $90 charge to access their records to verify employment. There are some consumer permission sources that allow us to have the applicant securely authenticate to their payroll system to pull back employment. One, it's almost instant. Two, it's very much cost effective. And three, it eliminates contact with that employer. So the prior employer can be verified without any notification to that, the employer that they're concerned about tipping off. And again, this one also contains a license verification. You can see that we ran the driving record and we pulled that back, verification that the license is valid, and then if there's any accidents, violations, and we're limited based on state by state what would come back. And you can see in this particular thing, it gives you a 3-year history length, so it's telling you for this particular state what's there. All right.
One of the things that as we go over to the messy one of the things I really appreciated about working with Tim is that we're able to set up multiple sort of profiles, if you will, or, types of background checks. So, when we log in for us or one of our clients, or if we're doing retained search work or whatever, and we're going to, as part of our agreement, background check people, we have different sort of levels, if you will, and how extensive we want things done. So you can set that. You can have multiple ones. You can say for all of this type of employee, this is what I'm going to do because it's, more job related versus somebody else. It makes it super easy. Make this a little smaller for you.
Perfect. Thanks, Linda. All right. So similar report. This is this particular person has an address history that's a little bit more extensive. You can see it extends to beyond Los Angeles as well as Idaho. And I want to point out something here. If you look at the SSN information, I want to make it super clear that when we're doing an SSN trace to develop identity, this is not to determine eligibility of hire and if they're truly a citizen, if the social is truly belongs to them. What this is an indication that the social was issued, the location it was issued, in the year. So there's a couple of things that can happen. One, if the person was deceased, it will say the SSN belongs to someone who's deceased. Or if the state, they never lived in that state and that comes up, that's an indicator. Or the year is a pretty good indicator, right? If the social was issued before they were born, that's going to be really challenging and tricky. So it's an indication of a potential issue going forward, but it's not a 100% guaranteed way to verify that this person is eligible for hire and that this social belongs to them. That would happen in the kind of E-Verify and Form I-9 process down the road. So I just want to point that out. So our reports, if you scroll down a little bit there, Linda, we do create alerts on our reports. In this case, it's red because of compliance and legal guidance. It's now changed to yellow because we are not giving guidance on whether to hire someone or not. We're alerting them to records that they should review to make that hiring decision. As a California employer, you are required to make those decisions. The background screening provider cannot give you a thumbs up or a thumbs down as to whether they're a good hire or not a good hire. The key things to look at, I think, are, the charges. In this case, you have a misdemeanor for shoplifting under 950. There's disposition of conviction or guilty there, and the offense states. Your background screening provider is going to adjudicate the records based on disposition date, making sure that for California, it's 7 years convictions only. That means non-convictions are not reportable in California. There could be situations where convictions going back farther are reported if, for instance, there's, extended prisons and probation and other things, mediating factors that go on. A lot of clients need to understand felony versus misdemeanor for compliance reasons. So you want to make sure your report contains that. And if there's anything in the report that is unclear as to what it is, you're going to want to make sure you check with your background screening provider and get clearance on what these charges are. In California, you become very familiar, but as you move throughout the United States, some of these charges are a little bit more abstract. And again, this situation, we profiled this applicant in the addresses that we developed and where he's reported, and covering them in Idaho as well as California. And as you can tell here, In this situation, under the National Criminal Database, you can see there's no records reported. However, there are some at the county level. So the reason I use this example is to prove my point that just because you run a nationwide search doesn't mean you're going to find everything. In this situation, the records were not found in the nationwide search. They were found at the county level, even though this person had some pretty, more serious level of felony offenses. Keep in mind the difference between a misdemeanor and a felony. A misdemeanor would be a punishable crime in California, less than a year of jail time. Felonies are going to be for a year or more prison time. So that's kind of the differentiating factor in terms of the severity. If anyone has any questions about how that plays out, I'm happy to talk about those offline.
Awesome. All right, let's talk about what happens when you do find that background check, because Curtis, you're going to say, you can't just fire that person. That's why we titled this the way we did, right? It says that's the
Right.
first thought everybody has is, okay, something showed up on the background check. I don't want to hire felons. Why are you going to make me hire a felon, Curtis?
Yeah, and thinking there have been some circumstances where I've worked with a client and something popped up, and my advice was to proceed with the hire and hire that person despite something popping up that was not favorable. So the process goes something like this. We mentioned that if you've decided you want to hire an applicant, you present the applicant with a written offer of employment that's conditioned on submitting to a background check. Once the applicant has received that offer, you can go ahead and do the background check. If something pops up on the background check that you don't like and you want to withdraw that offer, you have to first provide that applicant with a pre-adverse action notice that states what it is that popped up on the background check that you don't like. Provide a copy of the report, and then after providing that pre-adverse action notice that states what the conviction was that we don't like, the applicant, we're not employed yet, the applicant must be given 5 days to provide a response, 5 business days to provide a response of mitigating circumstances or evidence that the applicant has been rehabilitated and is no longer a risk of repeating that crime, that bad act. If the applicant provides a response, then you must consider that response and determine whether, as best you can, I'm not exactly sure how employers are supposed to do this, but determine whether the applicant has provided sufficient mitigating circumstances. And if the applicant has, then you proceed and you hire the applicant. If the applicant has not provided sufficient mitigating circumstances or has not responded at all, you can continue to proceed to withdraw that offer. And you withdraw that offer through what's described here as the adverse action notice. That adverse action notice must say that we are withdrawing the application, or we're withdrawing your offer, and you have the opportunity to go to they just changed their name. Formerly known as the Department of Fair Employment and Housing. Of course, California likes to change their agency names all the time. So it's just changed to the California Civil Rights Department. But so circle back, your adverse action notice must notify the applicant that they can go to the California Civil Rights Department and make a claim for the employer not properly following the fair chance process.
Awesome. Tim, anything you want to add to this?
Yeah, a couple things here. Number one, at the point that the background check is authorized, the applicant can then elect to obtain a copy electronically or paper. At the point the report's complete, assume that they are going to get notified and they can authenticate and view a copy of that report. As Curtis mentioned, the pre-adverse and adverse action notices do include a copy of the background report. But keep in mind, if at the time they receive the consumer copy or the pre-adverse action notice, at any time that they contest the findings of what's within the report, they're contesting the validity of the charges, that it's not them, anything about the report, a reinvestigation must be completed in a timely manner. And a timely manner is that the background screening company, or CRA as we're referred to oftentimes, has 30 days to reopen that file, reinvestigate, and to update that report. So if at any point in time you as an HR professional receive information like that from an applicant, you need to notify your background screening provider immediately so that can be dealt with. It's a pretty serious situation. update those things, and then again, fall back into that process. But those are the kind of the things that come up. Just understand that process and don't be scared. These pre-adverse and adverse action notices are, for us and for our clients, are loaded into our system or updated through our legal counsel and can be generated with one click to include all the things that Curtis is referring to. Main thing is addressing them, reviewing them, and then following the waiting periods as it relates to that process.
Right. The Fair Chance Act is actually in that respect is well drafted because it tells us exactly what to put in those notices. So we have forms, just like Tim said, that we can just plug and play that are already prepared with the exact language that you need to include.
Yeah, and that's great. And again, one of the many reasons I like working with Santoni is like they take all the pressure off. If we go in and do an audit and they say, oh, we run background checks, we give them these forms to sign. I always cringe because I'm like, when was the last time those forms were updated? Are they even compliant with California law? Like, I don't have to worry about any of that because I know that Tim's company is keeping that, updated. So let's go back and part of this adverse action situation is taking into consideration 3 things as it relates to the candidate and the job. So one of the things is the nature and gravity of the offense, right? So talking about what type of offense was it, and then how long has it been, since that person was convicted of whatever they're convicted of, and the nature of the job. And, it's distasteful, but the example that I actually dealt with a number of years ago was somebody who had showed up on Megan's Law list, right? Who had been convicted of sex with a minor under the age of 14. And so my initial response was like 10 years ago. My initial response was, yeah, convicted felons aren't protected under the law, but they are more or less now.
We are
right?
now.
From the standpoint of you can't just have a blanket policy that we're not going to hire felons. And so you need to take this into account in terms of the job as well. So for example, if that person has applied for a job at a preschool, then yeah, you're going to say, we're not going to hire you and go through that adverse action process, right? But you're not going to have to hire that person most likely. But if they're applying for a manufacturing company, how many kids under 14 are working in a manufacturing business? Probably none, hopefully none, right? In California, hopefully none. And so that's the type of individualized assessment you have to go through before you make a decision not to hire somebody or rescind the offer.
Yes.
And one thing, Linda, just to interject. So using Megan's Law as a resource for screening employees is highly, highly risky. And it says it specifically there, right? Just because they're on that list doesn't mean anything. You need to understand that the nature and offense that was there and was a conviction. So being on the sex offense registry could be long-standing. That could be for 20 years, but the offense occurred beyond 7 years. So the reportable offense may not be reportable. The sex offense on the registry might be. But again, that plays into the assessment and the gravity and the time in order to make that decision.
Yeah, Curtis, you wanted to add something?
Yeah, so the takeaway here is just because something pops up on the background check doesn't mean you can automatically withdraw the conditional offer. Whatever it is that pops up on the background check that you don't like, you have to do an individualized assessment. Linda gave an example that is kind of similar to an actual example that I dealt with once, and my recommendation to the client, the employer, was to proceed with the hire because the conviction that showed up on the background check didn't have any effect or impact on what the applicant was going to be doing, even though the person was convicted for something that was pretty terrible.
Yeah.
But still had to hire the person because they have protections now.
Exactly. So Curtis, bring us home. Talk about some of the penalties if companies are not following, the ban the box law. And then we'll take questions after this. So be sure to drop them in the Q&A section.
Yeah, these are so if you look through these, you're probably going to recognize a lot of these. These are your basic wage and hour discrimination and harassment types of damages. So if you refuse if you wrongfully withdraw an offer, you're going to have to pay. You might have to go back and hire that person and pay back pay from when you withdraw the offer to when you actually hired them. Or if you wrongfully terminate somebody because of not following the process, then you have to pay front pay or lost future earnings. You're also going to pay attorney's fees and other penalties that we have listed here. So it's a lot of the usual types of damages that we see for wage and hour harassment, discrimination types of claims. And the summary here is that it could become very expensive very quickly. Even though you think you may have made a minor error, just because of the way the damages and laws are set up in California, it ends up turning into quite a large expense. So it's important to nail down compliance with these laws.
And one thing to point out too, that the majority of the lawsuits that arise out of the screening process have to do with failure to follow basic processes, use compliant forms, and to do things in a timely way. The actual contents of the report may come into question, but majority has to do with, did you use the right forms? Did you notify the right person based on where they are? And again, it's becoming more and more, if you can be compliant in California, you can be compliant just about anywhere. But
it's so true.
The requirements dynamically based on state, city, provincial, county, different requirements in the authorization disclosure process is enough. It's not even possible using paper forms. So I wouldn't even recommend trying. But if you can do that part right, you're probably 98% secure that nothing bad can happen. So work with a partner that can help you with that, or an HR consultant or employment attorney, because having those forms right and reviewed is the key.
Yep, for sure. Thank you guys so much. Denise, I'm going to turn it back over to you.
Okay, perfect.
Because I have a feeling we have some questions. I can't click on that without messing up my screen. So I'm going to let you follow through on that.
No problem. We do have some questions. Just one quick reminder, if you haven't let us know that you need HRCR credit, HRCI credit, please drop it in the Q&A now so that we make sure that we follow up with you. One of the first questions we received is, we hired someone who we later found out had filed sexual harassment claims against her 5 prior employers. How can we protect ourselves before hiring this person?
Great question. I'm going to turn it over to one of you
because I stunned you.
$1 trillion question.
We get this comes up frequently, I would say, where, we get the call after, the current employee has filed. Sometimes it's workers' comp, sometimes it's, harassment, sometimes whatever, but they've repeatedly filed claims against employers. Sometimes they show up for and work 2 days, and then next thing you know, they're alleging harassment or alleging that they hurt themselves at work or something. And it's then that our clients find out, oh, we did some digging, or the insurance carrier, attorney, and investigator looked at it and found out that this person had done this multiple times. Is there anything that either one of you can suggest?
I'll jump in. I mean, it's an unfortunate situation. It does come up quite often. So remember, there's a lot of things that are possible in the pre-screening process to search for potentially civil litigation. However, discriminating and not hiring someone because you find they've sued their prior 5 employers and their managers is not really a justifiable decision, right?
Right. So
that's the tricky thing. Again, the vexatious litigant kind of search, it's kind of similar principle. I would just say that it's the behavior and their attitudes within their work environment, and having processes and protocols to monitor and deal with the behavior. And if something is to come up, I'd be triggered to the fact that you better handle it quickly and swiftly by working with someone like Linda and Curtis to deal with it. Because if you have a vexatious litigant like that and you terminate them for what you found out, I would almost bet anything that you're going to be the next one to be sued. So, I'll leave it there.
Yep. Completely understand.
Okay, great. We do have some questions flooding in. So can post-employment backgrounds be done for misconduct? So a workplace investigation be covert. So can you do it without them knowing?
You can start the background check, yes, without the employee knowing. But if you're going to take an any kind of adverse action, you do have to provide the employee with a summary of the report. You don't have to provide the details of who said what or what kind of facts or records were found, but you do have to provide a summary if you're going to take an adverse action.
Okay, great. If an employer makes a conditional offer and the background check results keep getting delayed, What is the recommended course of action that an employer should follow?
Yeah, I just want to interject here and kind of throw this to Tim. What if it's taken a background check company a month to do a background check, wouldn't you want a different background check company?
Yeah, Curtis, it's a good point. So unfortunately, we've been through some with COVID and the other challenges with weather and different things like that. And as you guys might be aware, in California, there was a law that was passed based on a case in Riverside County that is requiring California courts to strip driver's license and full dates of birth from court records. So unfortunately, we are seeing situations where delays are happening. If your background check is taking 30 days, then that's a problem. But there are outlying situations where that can't happen because the courts just aren't set up to handle the request. The question being is that, what do? You can, let them know the situation and continue on. The fear is you're going to lose the talented person, or can they start? That becomes a compliance issue. You're going to bring them on board before the background check's done. I would reach out to the background screening provider and find out a little bit more. Is this delay due to a court issue? Is it a service issue? Or are there potential records pertaining to them that need to be verified so you have a better sense of what's happening? Communication is always the key, and do that in a way that's compliant. Like, hey, we think they have 3 felony convictions. No, that's not what I'm saying. Hey, it's a common name. The person's name is Bob Smith in LA County, and there's hundreds of records to review in order to make sure that we rule out anything that could possibly be there. Okay, whatever it is, and communicate that back and forth both to the HR professional, the recruiting manager, and the applicant to make them aware of the process and keep them apprised. That's my best.
Yeah, let me add a couple of things, because I think that's spot on what both of you have said. And one of the reasons that I recommend Tim to people is because I like being able to pick up the phone and call a live person and talk to somebody and ask those type of questions, like what's going on? Why is there a delay? The other thing is to me, it's sort of like having introductory periods now written into handbooks. It doesn't really matter to me, right? There's no difference between day 89, day 90, day 91. And it's the same thing on background checks, right? Whether you allow the person to start or not, you're going to go through the same process, right? Either you're going to be able to rescind the offer, or in this case, let the person go, depending on what the background check shows. So let's go back to my very distasteful example, right? You hire somebody, you're running a preschool, you hire somebody, you might want to err on the side of caution and say they can't start till you get a clean background, or until at least you go through that process. But, so maybe a better example, but if you allow them to start and then find out that it's job related and you go through the adverse action process with them, I don't know that it makes much of a difference, Curtis, in terms of timing.
I don't think not that I'm aware of. You can delay your actions.
Well, you could delay the start, but as Tim says, you run the risk of losing talent, right? So if it's a Bob Smith situation, right, and they're reviewing hundreds of Bob Smiths to make sure it's the right person, maybe you have the person start, it's still, as long as the offer is contingent upon, as I always say, a successful background check, whatever that means, right?
Passing.
Passing a background check. So as long as you have that language in your letters, I don't know that it makes that much of a difference whether you allow them to start. If you have a situation like you're running a preschool or something where you want to be extra cautious, then maybe you delay the start pending the results. But to Tim's point, call and find out what's causing that delay before you make that decision.
Okay. We're at 12. Are you guys okay to stay for a few more minutes to get like 1 or 2 more questions out?
Yeah, there's a couple that hit on financial, so let's do those.
That was the next one. Curtis, you're a great lead-in. In California, we can go back 7 years for a background check, but this person who's asking the question said their industry is highly regulated through FINRA, and FINRA allows for a 10-year background. How do we address this with California employees? Do we stick with the 7 years, or can we extend to 10 due to the FINRA?
I'll jump in here on this. So as a California employer, you must follow the California laws based on those types of things. FINRA has that requirement as it relates to their licensing. So we see a lot of people in the financial space that hire people as an apprentice or someone who's training, and they're going to train them up with the intention of getting them a license. And they want to make sure that their background check is clear in accordance with FINRA. But you got to be careful because you're not working for FINRA, you're running a business in California. So it is possible to do that, but it's only an indication of what may be an issue when they do the FINRA background check. But in my opinion, using that as a reason not to hire them as a California employee could be a very risky maneuver.
Okay. What about a felon? So I guess when someone got a background check, it came back. What about a felon for financial crimes and the person is applying for a position in the financial industry? Do I still need to hire them?
Well, so it depends. You have to go through the process of the pre-adverse notice saying, hey, we found this and we would like to withdraw the offer, but you have 5 days to provide mitigating circumstances, or to maybe there's an error on the report and you want to correct and say, this isn't really me, this is someone else. Do the pre-adverse notice, 5 days go by, allow the employee to come up with mitigating circumstances or corrections, and then make an assessment of whether you want to withdraw the offer or continue to employ the applicant.
Okay. We have two versions of a similar question. One is, can you not move forward with the employment process if the potential hire does not sign off on the background check? So let's make that like a part one. And part two is if the employee refuses the background check, so similar to, can the employee sue the company for discrimination if they feel qualified for a position?
Well, so I think one thing you're going to want to do in the application and during the interview process is make sure that the employee knows that successful employment will be conditioned on passing a background check, so that the applicant knows it's coming. And if the applicant at that point knows it's coming, receives a conditional offer that says, here, sign this authorization, and then the applicant refuses, you could withdraw that offer because the offer is conditioned on a background check and the applicant's not letting it happen. Linda, how do you feel about that?
Yeah, I agree with that. Again, you want to just make sure, like we have this happen all the time. We'll log into the platform, we'll send a link to the employee, and that's, again, I know I'm pimping Tim, but this why I like working with Tim so much is because all you had to do is log in, choose the background that you want, the background check, the components of it, and you put the candidate's name and email address in there and it goes out. Well, we've certainly had situations where we mistype the email address, or, you know, they change the email address or something like that, or it lands in spam, right? So don't just make an assumption because it's been 2 days and the person hasn't completed the background check. I mean, try, right? Reach out to the candidate and find out what's going on. But if they're not showing up, you know, I'd move on to the next candidate.
Yeah, and a lot of times, just to follow up on that, a lot of the times the reason that the applicant doesn't complete that process is because they're worried about what may be found. So a lot of times clients say, well, you guys are not following up, you're not being fast enough. There's two things. One, they know they're going to, that they weren't sure if the employer is going to do a background check, and now they're seeing that they truly are. And two, they abandoned the position because during the background process, they recognize the fact that they're going to find something, and now they've moved on to some other employer where maybe there's background screening and onboarding procedures are a little more lax. So those things do come up. That is not always a reason why things are delayed or why the applicant doesn't complete the process, but we've seen it happen quite a bit, both in the background screening and the substance abuse screening process. Applicants are experts at delaying things for their benefit.
Denise, let's call the questions there. If people didn't get them answered, we're happy to follow up with you.
Absolutely.
Next month on April 13th, Curtis and I are going to be doing the webinar on pregnancy disability leave law. There's still a lot of confusion we see out there about what you have to do in terms of documentation, what the rules are. So we're going to be focused on pregnancy disability leave, both California and nationwide, at least, you know, at the federal level, not state by state. But if you have topics that you'd like to see covered in future webinars, please send me an email or give me a call and let me know what those would be. We're always looking for great topics. We want to make sure that we're providing you with the information that you want. Each of us has a slide in here. Denise, if you could drop that, if you still have the link, can you drop it in one more time to the chat so people that maybe didn't get the slides before can download them?
Absolutely.
That would be great. And then reach out. There's, again, bio slides for each one of us. So reach out if you have any questions. If you're looking for a background check company, clearly I highly recommend Tim. So reach out to him and he'll put you in touch with his background check team. Thank you all so much. Denise, as always, thank you for moderating for us. Appreciate everybody. Have a great day.
Thank you.
Have a good day.